Well, now you get to link the name and the face for this class. I'm going to do a few minutes and really not spend a lot of time, frankly, talking about proximate cause. The main goal here is to get you thinking about this idea of causation. It's a troubling area of the law, not because we don't want there to be something and not because we can't grapple with it at all, but because it's just hard to get our hands around what we mean when we say proximate cause. What we know, and what you should know from your reading, is you don't mean but for cause alone in any event. The reason for that is obvious. Let me give you an example. My dad was in the military for many years. During the Vietnam War, he was stationed in Thailand, which, if you know your geography, is right next to Vietnam and actually borders on North and South Vietnam. Well, one of the things that he was told when he got to Thailand, or before he went, I guess, was don't hire a taxi in Thailand. You say, well, why not? Well, one of the reasons that they told the soldiers don't hire taxis in Thailand was because if you hired the taxi, you became responsible for anything that happened while that taxi was in operation. Now, for us, as Westerners, that seems awfully peculiar, particularly for Americans. We have ingrained in us this idea of individual responsibility, and so we would naturally think, well, the driver's the one who caused the accident, or somebody else may cause an accident. But in Thailand, the thinking was, no, you hired the taxi, and therefore, guess what? The taxi would not have been in the place it was in but for you hiring it. Therefore, you have some responsibility, if not total responsibility, for the consequences of the driver's actions. As a result, my dad, needless to say, in his year in Thailand during Vietnam, decided not to hire any taxis for that reason. He didn't want to be responsible just in case something happened. That's but-for causation at its, not even really at its extreme, but at an extreme that we would find puzzling, I think, regardless of our understanding of the law. I just think generally, as Westerners and particularly as Americans, those of you, and I guess I'm assuming most of you are Americans, but if you're not, you're certainly immersed to some extent in American culture, perhaps. That just isn't the way things get done in the American system. And so as a result, that seems kind of foreign, probably for most or all of us. Proximate cause gets us past that simplistic notion, because but-for cause obviously isn't going to work as a means of determining who's at fault for something. It just simply can't. It's unworkable, and it's obviously unworkable. The reason being the simple example of the old, and it's in the book, so I will mention this because I think it's funny, the old, for want of a nail, the shoe was lost, for want of a shoe, the horse was lost, for want of a horse, the rider was lost, for want of the rider, the battle was lost, for want of the for want of the battle, the war was lost, and for want of the war, the kingdom was lost. So the reason the kingdom was lost, ultimately, is because the horse's shoe was lost. Well, that's a but-for causation, yes, but proximately, is that really the reason the war was lost? Well, maybe, maybe not. I mean, it gets attenuated to the point where we don't like saying that's a legal cause. It would be as if somebody dropped a nail off of a truck. It landed in a roadway. It got stuck in someone's tire. The tire, over a period of 6 weeks, started to lose air. Eventually, that tire lost enough air that it became dangerous. The driver of the car whose tire had the nail in it, you can see where we're going with this. I mean, do you really want to go back to the guy in the truck that the nail fell off of and say it's his fault that this guy then has an accident 6 weeks later because air had slowly come out of the tire? I mean, we could, But again, it starts to get to that point of attenuation. So the idea of proximate cause is trying to get us to a point, and then the reading as you do it and the reading of the cases as you do it, keep in mind that you're trying to find a way in the law and the judges who make it in terms of tort law and the legislators who pass legislation, they're trying to find a way to make some sense of where to draw lines here. We're trying to, do we draw it here? Do we draw it here? Do we draw it in a way over here? Where do we draw that line in order to sensibly get an understanding of whether or not the conduct in question is what we call the proximate or legal cause. And you can see why it's so muddy and difficult to get your arms around. It's not the easiest thing in the world. The book discusses the directness test and the foreseeability test and does a good job of outlining what those two tests, how those two tests work, and how ultimately you kind of get a cohesive togetherness with both tests. So I won't review all of that material with you directly. I do have some notes jotted down that I will refer to in order to mention a couple things about that I want you to be thinking about as we're looking at this. I think one of the examples that the book gives that I think illustrates the problem with the directness test is the tree that falls down on a speeding train, and the person argues, well, if you weren't speeding, you wouldn't have been there when the tree fell. Well, yeah, that's true, but clearly we don't want to penalize someone who had nothing to do with the tree falling. A tree gets struck by lightning, falls over on a train, and it causes an injury either to property or to a person. Nobody can predict lightning. I mean, that's just ridiculous. And so whether you were speeding or not becomes irrelevant. You're not obligated to be prepared for that kind of eventuality. And that's one of the reasons why the directness test fails, because it's a direct, there's no question the speeding is a direct cause. Again, it's sort of a but-for cause, but it's not good enough. And so we run into problems. Foreseeability, the other concept, and I know I'm talking about the book a little bit, but that's the other major concept the book discusses, and I want to touch on it briefly just so that I get you thinking about it. Foreseeability involves, as the name suggests, well, are the consequences of the conduct foreseeable? But then again, there's problems with that test because from a standpoint of cause, because conduct can have all kinds of eventual results, some of which may be foreseeable and some of which may not necessarily be foreseeable. But what if the foreseeable consequences are modest, but the unforeseeable consequences may be truly significant? And so you run into this difficulty of, well, that alone may not be sufficient because, gosh, it does seem unfortunate that I can't foresee that my action is going to have a particular consequence. For instance, and the book mentions the eggshell plaintiff rule. That's essentially a rule that says, look, if you've got somebody who is extremely susceptible to injury, even though that's not foreseeable, because you have a sort of a right to assume that people are not necessarily going to be injured easily. You sort of get to believe that people are sort of injured, I guess, in a normal manner, right? But so let's say you are riding a bicycle and you are going very slowly, but you nick a hemophiliac who then bleeds out. Well, it's not foreseeable that a person who gets nicked by a bicycle as you're driving by them would bleed out and die. I mean, that's just not foreseeable. You're going slowly. You barely touch them. You don't realize that you've even cut them, and they end up bleeding out and dying. Well, that's not foreseeable, but it is your fault that you did do that to them. And so then the law has to figure out, what do we do about that? There's sort of a patent unfairness inherent in the idea of you having to foresee that you might run into hemophiliacs. On the other hand, there's a patent unfairness to the hemophiliac that you injured them and have to suffer no consequences. just because they happen to be someone who you could not have foreseen doing this to, and you couldn't have foreseen the consequences. So you can, again, you see that that test isn't sufficient. And so we run into the problem, well, what do we do about these things? How do we manage this? And if you haven't figured this out already in the study of legal matters, it's squishy. It's squishy. And it's sort of never always obvious, and it's never easy. And so we do the best we can with what we've got is really what it boils down to. And so this idea of proximate cause becomes one of I think, and in years of practice and in years of doing tort cases, handling defense of car accident cases for many, many years, what I concluded was that people sort of had a gut reaction to proximate cause. They kind of intuitively would fumble around with it. They would sort of manage, and juries would get together, and you'd get, in Virginia where I practiced, there were 7 people on a civil jury. Those 7 people, in my experience, would usually fumble around with it in a manner that was sufficient. That they kind of put their heads together and look at the situation and decide whether they thought it made sense. And it was sort of a horse sense kind of idea. Does it make sense that this accident caused these damages? I'll give you a for instance. I tried one case, and I won't regale you with too many of these war stories. I'll try not to do that to you. But I think it does help to understand. I had one case where this little boy, who was 10 at the time, was hit by a guy riding a motorcycle. While the guy who was riding the motorcycle was, I think, 18 at the time, he was riding around in a local park. He wasn't supposed to be there, and he did hit the boy, and he did cause the boy a broken leg. The plaintiff attorney tried to argue that this young man had some sort of sports career ahead of him. Well, there's no question that my client was the proximate cause of the young man's injury. There's no question about that, no doubt about that. He was. He did cause the broken leg without question. The little boy was 10. In Virginia, children between the ages of 7 and 14 are presumed incapable of negligence. So there was no contributory negligence, which is the standard in Virginia. And so, well, I had to really work hard to prove it. I didn't really try very hard because I felt like it was pretty obvious. The guy on the motorcycle should have been paying more attention. He was an adult, and he hit the child and caused his broken leg. But it was a bit peculiar to suggest that a 10-year-old that we had any idea whether this young man was the next Michael Jordan or whether he was, not. And the odds are, obviously, that he was not going to be the next Michael Jordan. For those of you who would prefer a football reference, the next Tom Brady. How about that? And baseball, I'm sorry, I'm not a great baseball fan, so I'm not even sure. Vlad Guerrero, I think, is a recent example of a very good baseball player. Here's the point. It's not foreseeable that a 10-year-old is likely to become the next sports superstar, and that factors into this discussion. And that's one of the ways that we look at proximate cause. It's not so much was the motorcycle hitting him the proximate cause of his broken leg, no question, but was it the proximate cause of the damages as well? And so that's also part of the analysis that the jury has to circle around and that judges have to think about. I didn't worry about asking the judge. I don't remember if I moved to exclude those kind of damages from consideration from the jury. I probably did because I probably thought it was ridiculous. I don't know whether the judge let the attorney argue it or not, but I want to say, it's been a number of years. I want to say that when the judge kind of hemmed and hawed about it, I just said, well, whatever, you do just whatever you want, judge, I don't care. And because I figured it was kind of ridiculous to make that kind of argument. And in fact, it turns out that the jury in Virginia Beach didn't really buy into the idea that this 10-year-old boy had any necessary likelihood of becoming the next big sports star. And so the damages were limited for that reason. Now, they understood the broken leg, and they understood that it was clearly a result of the motorcycle crash. What they didn't understand was how are these damages also proximately caused by the accident. So that's another part of that test, and it helps us to rein in the other questions. And what I'm trying, the point in telling you that story is to show that on the back end, we have a methodology for helping to put a circle, if you will, a fence around the issue of causation with the damages assessment. And so that too factors into this discussion of proximate cause. It's not just did the tortfeasor cause the injury or cause the accident or cause the event, but did the tortfeasor's actions in causing the event result in the kind of damages that the plaintiff or the injured party is claiming? And that helps us to sort of rein in some of the potential problems with the difficulty of figuring out whether where to draw the line on the actual causation. So just keep that in mind as you're thinking through, and particularly as you're reading these cases. Palsgraf, one of the cases you will read, is one of the most famous proximate cause cases ever. It's a lot of fun to read. It's a crazy situation. If you haven't read it yet, I won't give it away. And I won't discuss the details of it, but just enjoy reading that because it's just a crazy it's a crazy case, and it's an interesting discussion of where exactly do we draw lines and how do we do it. As you'll note, I'm not talking in terms of directness and foreseeability and kind of contrasting them. I'll let you read through the book. I'm just sort of kind of generally discussing how this all works and how you put it together. The last thing I want to talk about very briefly is joint tortfeasors. You have several things going on with joint tortfeasors. Obviously, each tortfeasor who's involved in a situation has to be a proximate cause. They don't have to be the proximate cause, but a proximate cause of the accident and injuries. So, for instance, you could have a car accident, and this happened to me on multiple occasions, defending cases where there were multiple potential bad drivers, if you will, who had some hand in causing the car accident. You know, the question was, well, how did that all come together? This was a frequent problem with multiple rear-end collisions, particularly, and those of you who are familiar with the Hampton Roads area of Virginia, particularly in the Hampton Roads Bridge Tunnel. It doesn't seem to happen quite as frequently in the Monitor Merrimack Tunnel, but that was often a conspicuous difficulty. You've got a lineup of cars, and you got bump, 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 3, 4, 5 bumps, or maybe significant crashes. Who hit who when, and how much of the fault is on which cars hitting which people, harming which people. And so you can see how that idea of joint tortfeasors might fit in. It could fit in other ways. You could have a situation where you have a train that the old case law of a train starting a spark, which caused a fire. But then you also have somebody who had let's say a leaky oil, not well, but an oil container. The leaky oil container also is negligent for letting that oil get out, and the spark hits a dry field of grain, let's say, that's next to the railroad track. But the leaky oil container, is also a problem, and just as the fire is getting ready to die out, it hits the oil, and boom, it reignites in a bigger way, and the whole field gets burned up. Now, whose fault is that? Is it the train's fault for starting the fire, or is it the oil containers, the owner of the oil container's fault for having the leak? Is it both their faults? That's the issue of joint tortfeasors. Again, each one must be a proximate cause. Once that happens, they both are responsible. Either or, both are responsible. And if only one, the person who receives the damages only has to go after one of those joint tortfeasors, and the other one can seek what's called contribution or indemnity from the first one. Technically, contribution and indemnity are two separate issues. Indemnity is usually where one person says, if it weren't for you, none of this would have happened, therefore you pay everything. Contribution is normally a matter of a joint tortfeasor saying, yeah, I know I have some fault, but so did you. You need to pay me for your share, if you will, of the damages. One last issue that does come up, and that is the issue of a superseding or intervening cause. The book gave a good example, so I'll just jump on it, and that is the example of a lightning striking and intervening in between somebody else causing a fire, for instance. The lightning strikes, and did the lightning it makes it worse? I can't remember now off the top of my head what the book was saying, but the point was the storm made the situation worse. The storm wasn't foreseeable, it was unexpected, and it made the situation significantly worse. Well, is that an intervening cause or a superseding cause? Does that sort of stop and put an end to the causation of the original tortfeasor? That's a question, basically, as we like to always say, it's a question for the jury, ultimately, or judge, whoever the fact finder is going to make that determination. But that's another thing to consider as you're rummaging through and thinking about this and working your way through these cases and through the book. That's another thing to think about. All right, well, go at it, and I will continue to work on grading things. I know I'm lagging behind you a bit, and that's just partly the nature of the beast. But keep at it, keep working hard, and I appreciate all your hard work and your thoughts and your analysis.